welcome to today's panel as part of our launch series for the new Journal of Free Speech Law, brought to you by the UCLA Institute for Technology, Law and Policy, a collaboration between the UCLA School of Law and the Samuel Lee School of Engineering, whose mission is to foster research and analysis to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. My name is Michael Karanicolas. I'm the Executive Director of the Institute of Technology, Law and Policy. I'll start by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tonga peoples. And I'm very excited for this panel conversation. So I will move straight into our introductions. Jordan J. Wallace-Wolf is the Greenberg Fellow at UCLA Law. Frederick Schauer is a David and Mary Harrison Distinguished Professor of Law at the University of Virginia. And Ash Bhagwat is the Bukover and Bird Endowed Chair for the Study and Teaching of Freedom and Equality and Martin Luther King Jr. Professor of Law at UC Davis. And our wonderful moderator today, Jane Bambauer, is visiting affiliated faculty here at the Institute for Technology, Law and Policy, as well as a professor of law at the University of Arizona. Jane, I'll pass it over to you.
Thank you, Michael. All right, welcome to the sixth in our series of conversations with folks who have authored articles for the Journal of Free Speech Law. We're here today to discuss freedom of thought, which is nice because it's different from the first 5 sessions which have been on the topic of platforms. So it's nice to have a little bit of a variety here. So I'll ask Jordan to start by describing the article that he published with us. And then Fred will give some commentary, which is especially fitting given Fred's stature in the freedom of thought and free speech literature.
Great, thanks. I really appreciate it, Jane. Thanks for having me, and thanks for the Institute for putting this on. And I'm thrilled to be here. So I'll say a little bit about the paper. So the paper is about what a recent appellate court called the centuries-old legal maxim, according to which persons should not be punished for their thoughts. And this appears to be a categorical rule, and it's widely celebrated and widely endorsed. The appellate court in that case upheld this rule and spoke highly of it. So I'll just refer to it as the thought crime doctrine, that you can't be punished for your thoughts. But the question that my paper takes up is what can justify this doctrine, as popular as it is, as excellent as it seems, and as important for the law as it seems, what could justify it? So if we ask this question, actually, it's kind of hard to give a good answer. And if we can't give a good answer, we might feel the need to modify or reform the rule to comport with the answer that we can give. But my paper says that the rule is good as it is. I argue that there doesn't need to be any reform to the rule. It's a good rule, and there is a justification for it. There's a deep justification for it. So I'll just very briefly say some of the going views about why we have the thought crime doctrine refer to kind of ancillary features, or not the value of thinking. So they say that our thoughts are innocent, they can't hurt anyone, or they're very hard to determine, so the legal system shouldn't try to take aim at punishing them, or that they're not dangerous, or other combinations of these ideas. But the difference that I don't think these justifications are fully persuasive, because we can find out what people think. We do that all the time in law, and we can get better at it, actually, with technology. We might be getting very good at it soon if we can read people's thoughts with machines. And I also don't think that the justification has to do with the abuse that the rule could be allowed to, could spawn among police forces or prosecutors. I think even an honest prosecutorial and police system would need the thought crime doctrine. So let me just turn to what I see as the main justification for this rule. I kind of give an extended argument over a few several premises, but I just try to condense it down very simply here. The main premise that the argument works on is that there's something distinctly valuable about the freedom to think what you want. And so the way I'll put it is that thinking is a distinct species of a category of activities that I call figuring things out. Let's call it that, figuring things out. So thinking is the core kind of paradigm species of that activity, because thinking is how we make all of our other decisions and actions, and anything else we do that's good, we do by virtue of having done some thinking first. So for example, if I'm going to use the freedom to move, if I'm going to use the general liberty to move around, the freedom of movement, I'm going to need to know where I want to go. And I'm going to need to think to figure out where I'm going to want to go. If I'm going to know which persons I want to have relationships with, what sort of activities I'm going to engage in with them, I need to know my identity. What is my sexuality, for instance? What is my religion? So thinking is kind of at the core of figuring oneself out. And there are other activities that also help one figure oneself out. But thinking is kind of a core activity, and it's very important. Then that's the kind of the major premise, the major moral premise of the paper. And then there's a minor premise. And the minor premise is that if you punish someone's thought, you are punishing their thinking. You are striking at their thinking and interfering with their thinking in a way that substantially limits it and substantially restricts it. And so insofar as thinking is valuable, insofar as it has a distinct importance for people, punishing it will trip over that importance. It will interfere with that importance. And this is what grounds the categorical rule that thoughts should not be punished. So I'll just give one example. You have a belief, you're trying to figure out what to think about vaccines. Am I going to get one or not? And you have the belief vaccines are dangerous. They're harmful to me, so I won't get one. But the belief is that they're dangerous. We have all sorts of reasons that we don't want people to have that belief. We have pragmatic reasons for not wanting them to have that belief. If depending on your own view of the matter, you might think it's not true that vaccines are dangerous. So that's why we don't want people to have that belief. But my argument is that people get to have the belief that they arrive at because that's their thinking. There's no other way other than for them to think whatever they think is persuasive or plausible, and then to sit with that. And perhaps they'll change it, perhaps they won't, but that is their thinking. And so to punish it kind of strikes at the core of their self-creation or figuring themselves out, as I'm talking about. And so that's impermissible. And so just to close, the real kind of hard question for an argument like this is, what about intentions? So beliefs seem to be a lot easier to show that you shouldn't punish them because it's just a belief. Like, you're not going to ever act on it. Like, people believe all sorts of crazy things. Like, okay, why not just let them? But intentions are different. Intentions are preparations to act, commitments to act. And so insofar as someone has an intention that is a commitment towards a wrongful act, like robbing a bank, we're going to be worried about that as a society. And so you might think, why not amend the thought crime doctrine to allow the punishment of intentions? And I won't get into all the details here, but basically I argue that intentions are a type of thinking in their own right, and they play an important role in a person's overall activity of figuring themselves out, not as paradigm as beliefs, but nearly so, because to believe something about, for example, to believe what it would be good to do, that belief is hollow or empty unless you can also intend to form the corresponding intention to act that way. So I might think it's good to go to the store, but if it was criminalized to form the intention to go to the store, I wouldn't really be able to fully appreciate that thought, that belief that it would be good to go to the store. So in the end, I tried to say that intentions and beliefs and possibly other thoughts too, the paper doesn't address those, are important to thinking, and thinking has a distinct value. Therefore, the doctrine makes sense because it preserves this value for people, individually speaking. So that's a good summary of the paper, I think, Jane.
Great, thank you. Fred.
So this is an interesting and important paper. I want to ask a few questions about it, questions that are a little bit on the skeptical side, because as I'll talk about in a few minutes, I have a more broad-based skepticism. But one of the things that's less skeptical, possibly at the outset, is just my own curiosity about what role is punishment doing in this account. That is, there are lots of ways in which the state or anybody with any power can regulate, can control, can do all sorts of other things to people. Is this an argument? Is this an account about the criminal law? If it is, what is it about the criminal law as such? If it's not, then why focus on punishment as opposed to numerous other ways in which the state or others in power might be able to regulate, be able to control, and so on. So that's one cluster of questions I'd like to hear a little bit more about. The other cluster.
Actually, can we have Jordan respond to that and then
Sure.
Okay.
Okay.
Yeah. Oh, great. Yeah, thanks.
That way he doesn't have to remember the next.
I was starting to take note. I could have remembered that. I appreciate it. Thank you. No, I think I think the answer to that question, I think maybe will not surprise you. I think pretty flat-footed response. I do think the thought crime doctrine will have the value identified for it will have implications beyond punishment. Definitely, I think that. So I don't think torts that are related to someone's thought are going to be very well grounded either. They're going to run afoul of this same value. I focused on punishment just because I think there's kind of a minority report-ish question about what about crimes? What about people who have seriously bad thoughts? And that's kind of a limit case and an extreme case. But as maybe we're going to get into, maybe the argument generalizes too rapidly, but I definitely think it's supposed to generalize beyond criminal law. Yeah.
So picking up on what you just said, I guess I have an interest or curiosity about what we might want to call upstream behavior. That is, we often talk about downstream effects. I'm interested in your paper. Prompts me to be even more interested in, let's call it, upstream behavior. That is, what is the range of, and I'm not sure what I should call it. I could call it acts, I could call it conduct, but that's a little bit question begging. What's the range of, to use the appropriate technical term, stuff that is upstream from actual conduct? And it seems to me that at least one of the things we have to think about is to what extent are thoughts upstream from actual conduct. Now, it is of course true, and I'm jumping ahead a little bit to something that I've written about in mine. It is of course true that you can have a thought and not act on it. But a fair amount of the law, including a fair amount of the criminal law, is unwilling to draw the line at that point. I'm particularly interested, for example, in what are generally referred to as preparatory offenses. Burglar tools, common preparatory offense. I can own burglar tools, but not commit a burglary. And there are lots of other examples of the same kind of thing. So I'd be curious to hear you say a little bit more about why you draw the line, where you draw the line in terms of thoughts. Or that is, yes, thoughts are preparatory to intentions, intentions are preparatory to acts. If we are really concerned about the acts, why should we not be equally concerned about that stuff that is both preparatory to the act and by hypothesis, causal of the act, assuming that we have a conception of causation that's probabilistic and not deterministic.
Yeah, so I love the example of the burglary tools. I use it in the paper as well. So the thought here, I think you crisply really lay out the central question that the paper is trying to answer, which is, okay, beliefs lead to intentions, intentions lead to actions. If the probability is significant, if the probability gets high enough, why not just cut things off there? Why allow a person's thinking to evolve into an action that we can rightly criminalize? Let's assume it's uncontroversial that we can criminalize the relevant action. And when the probability gets high, as that's what happens with burglary tools, arguably, you shouldn't be able to own them, not because you absolutely will use them, but because, like, why would we risk it, or what would be the interest there? And so what I want to claim is, I do think it's like that. I do think an intention probabilizes its action. but I think that the interests you have in so to speak, like owning your thoughts, owning a dangerous intention, the interest you have in that is much greater and of a different variety and character than the interest that you have in owning burglary tools. And the reason is I think because intentions are a way of thinking, where I don't think burglary tools have nearly a strong connection to thinking, if any. So the view tries to draw the line. It doesn't draw the line in any one place for all time. It just tries to say there's this value, and then depending on how connected something is to that value, that will be important in determining whether it can be criminalized or not. And so there's a strict line at intentions, just because I think intentions are very, very related to thinking, and it's a kind of a natural, crisp point at which you can distinguish wrongful, criminalizable behavior, conduct, stuff versus non-criminalizable stuff.
So one more cluster of questions, but I want to precede it by a observation. I try to avoid making my scholarship too relevant or too timely, but it is worth noting that one of the important news items of today about the shooting in Michigan is the fact that the 15-year-old shooter was observed by his teacher the same day or a day earlier, making drawings of people being shot and bloodied by a gun. Lots of us make drawings all the time. But how should we think about that drawing? How should we think about that unacted upon manifestation of thought? So, but I guess for me, and this relates a fair amount to the way I've been thinking about free speech for a long time, whether correctly or incorrectly, is what's so special about thoughts? Obviously, you say it's a matter of self-creation or figuring yourself out or whatever. Do we figure ourselves out? Do we create ourselves by what we think, or instead by what we do or what we experience? Is there some sort of a special kind of cognition involved in what you want to describe as thinking that's different from the vast number of other ways in which we are and become what we are?
Yeah, so good. So I could take those in turn. With regard to pictures or drawings or diary entries or sketches or various ways people kind of work out their thoughts, the view that I have doesn't claim that there's no action that can be taken if you find out that someone has thoughts that are negative or criminal. The thoughts themselves can't be criminalized. And I also think there are going to be privacy protections for how much you can try to get at their thoughts. But now, if the thoughts just come out, the teacher sees them, the teacher rightfully sees them, let's assume she doesn't, raid the desk or whatever, then action, nothing in my view says that action can't be taken on that basis. So that, I think that's an important clarification to make. And then with regard to your second point,
Can I ask, like, when you say action can be taken, you mean like sort of surveillance and cautionary stuff, but not criminal punishment, I take
That's correct. Yeah, I don't think criminal punishment can be initiated, but yeah, that's very helpful. Yeah, surveillance or extra security or time away from school, all those things are possible under my view, under this argument I've given so far. And then, so to the second point is, I took particular interest in your article in this. This is a theme of your article. What's the difference really between thinking and other types of ways we change our viewpoint of the world and grow as people? That's an almost unlimited list of activities by which we grow as people. And that's an important point. What I want to try to argue is I think thinking is distinct in the sense that of all the activities by which we figure ourselves out, thinking is the root activity. We also figure ourselves out, the activity of figuring ourselves out heavily depends on things also like getting information. But I think there are First Amendment or thought-related protections for getting information. I think actually the freedom of movement is actually partly dependent on the fact that we need to be able to go and see the world for ourselves. So think for yourself, I think, is a cognate of see it for yourself. Those are related. Those are two ways we internalize things for ourselves. But seeing it for yourself is a little different, and it's not subject to the same types of protections that thinking it for yourself is. And why is that? Well, one is because to see something for yourself, you have to put your body somewhere, and bodies raise interests with other people that thinking doesn't. So like bodies can get jammed up or can be stampeded or transmit disease, etc. So I think then that there's a distinct role for thought, and other things will be related to it, and they'll earn some protections too. So again, I do think freedom of movement earns some First Amendment protection. I think freedom to receive information receives some First Amendment protection, but it won't be unlimited because that won't be nearly as related to figuring yourself out as thinking. Thinking is kind of the route by which you do it. If you can't think about something, you're never going to develop yourself. You're never going to arrive at a view of what you care about and want to do and convicted in.
Hey, I think that, oh, go ahead, Ash.
So I think this may have to do with the fact that I think of human beings as more social than isolated, but it seems, rereading the discussion of incitement in your paper, and it seems to me that if we think of thinking as more of a joint activity, why is incitement not thinking? It's trying to convince someone else to think a certain thing, but isn't that part of the way we develop thoughts? Is not in splendid isolation, but within communities. And
Great,
so why doesn't your doctrine suggest that incitement should be protected?
Okay, good. I do think actually that thinking is heavily social. So I think actually that a majority or the most important part of our thinking definitely takes place outside of our mind. Outside of our single solitary mind. So like libraries, I think, are crucially important. Education is crucially important. And so is speech. I do think there is a relationship between freedom of thought and speech precisely along the lines of the sociality of thinking. Okay, so then your question is, why wouldn't incitement be protected? And what I want to say there is that incitement is the limit case of the high amount of protection that we give to, but not unlimited, protection that we give to thinking together. So general free speech protections allow me to say quite offensive things, ridiculous things, untrue things in some cases. But incitement, I think, is a special kind of case because it's a case where you take responsibility for the thinking of another person, where you're not just interlocuting, you're not just offering thoughts and receiving them, you're exercising direct control over. So like, think of an order. I think of incitement as the closest thing to an order that's not an order. So an order is action, is an attempt to get someone to act by words. You use words to do it, but you don't, the nature of an order is not an idea. The nature of an order is a command to action. And
isn't an intent to do something in order to yourself? I see the parallel that he's getting at. That okay, good.
Good, yeah. So the difference that I see there is precisely the difference that the incitement is going to be is precisely because it is interpersonal. So you're going to be taking responsibility for someone else's action. Like you say, when you make a request, you say, "Will you do it for me? Will you do that for me?" And to me, that locution is getting at the fact that a request or a command is you saying to the person, act. I won't tell you the reasons. You act on my authority, act on my say-so. And that is something you have to take responsibility for, precisely because it's not you who's going to carry it out. But when you take responsibility for your own actions, the intention doesn't require you to be punished or criminalized, even though you are committing yourself to the action, to take the action. I don't know if that helps.
Let's
talk more about.
yeah, well, I suspect we'll get back to some of these
Yeah.
themes. Fred,
Yeah.
do you want to tell us about your article in I forget what the SP and
Social Philosophy and Policy.
That's it, Social Philosophy and Policy Journal.
Okay, sure. So some of which I've implicitly just been talking about, and some of the questions and things I've asked, but it's basically, it's an article with entitled Freedom of Thought with a question mark at the end. So it is, it's skeptical both conceptually and normatively. So part of the skepticism is just what is it that we are talking about when we say freedom of thought? That is, what operationally would follow from the existence of freedom of thought. And although everybody talks about freedom of thought, it's not entirely clear to me what they mean in terms of how to operationalize it. And that's why I'd start this part of the paper with my mention of the old German folk song that became more widely known because it was sung by concentration camp prisoners, Die Gedanken sind frei. That is, thoughts are free. And what the idea was that there is something inherently private and personal about thoughts, and the state can't reach them even though it wants to. Now, this is a little bit technologically and chemically obsolete, but still the basic idea of it is when we talk about freedom of thought, when we want to operationalize freedom of thought, exactly what kinds of operations or what kinds of actions by the state or someone else are we worried about? So I have some skeptical questions about that, that of course run into some questions about what is the line between how might freedom of thought be interfered with, and what, if anything, is wrong with propaganda or persuasion or a whole bunch of other things in which people are trying to get people to think of things other than what they have, what they are now thinking about. Propaganda is the extreme case. Persuasion is the less extreme case. Are there rights that are being violated when we try to persuade someone of something other than what they now believe, especially if what we are using is any of the full range of what we might call persuasive techniques? If I yell, if I use a catchy example, if I say it over and over again, if counterfactually I am good looking with a wonderful voice, there are all sorts of things that people in general, in Madison Avenue in particular, use to try to get people to believe things other than what they believe, other than the strict power of argument. So at least one set of skeptical views I have is, are all of these interferences with freedom of thought in some way? And if intuitively we think they are not, does that undercut the idea of freedom of thought? Now, that's different from a range of other skeptical views that I was just talking about in my questions a few minutes ago. That is, what is it that distinguishes thinking from a whole range of other human activities? I thought it was telling that Jordan thought of freedom of thought and freedom of speech and freedom of movement, all as being part of the same cluster. At some point, is that a cluster that begins to look like freedom full stop, or liberty full stop, or autonomy full stop? And at least the American constitutionalist in me, or let's call it the post-Lochner American constitutionalist in me, wants to say that what's interesting about a right is dependent upon there being something about it that distinguishes it from undifferentiated liberty or freedom or autonomy. It's not clear that there is such a thing for me, even for freedom of speech, certainly for freedom of movement, and at least arguably for freedom of thought as well. That is, to summarize that skeptical thought, is there a difference between freedom of thought and freedom? And I'm not sure that there is. And I think the justification of those who talk about freedom of thought is a little heavier, or the burden of justification is heavier than we commonly think. Now, one other thing I wanted to mention now that just related to what Jordan said about how we would find out about someone's thoughts, that it came out a little bit when you said we ought to be open to restricting our 15-year-old shooter in Michigan, even if not punishing. So that goes back to my first question about, is there something special about punishment? But if it's a matter of restricting, short of punishment, then again, are we talking about something in particular about punishment? But here it reminds me of the somewhat less well-known opinion of Justice Harlan Jr. in Griswold. So in Griswold, Justice Harlan Jr. Is less hung up about the kind of privacy that Justice Douglas is talking about, but Justice Harlan is worried about just what would be the mechanisms that the state might use to restrict use or access to contraceptives. That is, he makes almost the Fourth Amendment argument and saying, in effect, the only way to actually restrict this would be to get dangerously near to physical invasions of privacy, unreasonable searches and seizures, and things of that sort. And I think maybe that's a worry that you have, but then at some philosophical level, that strikes me as an instrumental or pragmatic worry that doesn't really go to the heart of whether there's something distinctive or special about freedom of thought as such. Okay, so I should leave it at that to let you and others chime in.
But I did have a question.
Sure.
I will confess, I share your skepticism about freedom of thought, but how do you feel about truly like changing people's thoughts in a way that is truly bypasses their mind, like subliminal advertising? And how would you feel if the government decided to subliminally convince everyone to vote Democratic in the next election?
Right.
There's an instrumental problem with that, of course, which is, but is there also some sort of essential autonomy problem with that?
Yeah, I mean, the reference to subliminal thoughts is interesting because at least one of us in this conversation, that would be me, actually remembers when this kind of thing was front page news in the 1950s. There was a sort of 1984 dystopian discourse about subliminal advertising in the 1950s. So now we are into the realm of cognitive psychology, Nothing wrong with that realm. It happens a fair amount in my own family. But then the question is there anything different about subliminal advertising from the various other forms of persuasion? That is, when I am more persuaded by the speech of someone who's good looking rather than less so, does that go through my cognitive processes or does it go around them? When I am more persuaded by something I hear 14 times rather than something I hear once, when I am more persuaded by something that's dressed up with nice pictures and everything else. So I share your worry about the government using its powers to get us to vote one way rather than another. I'm not, but I might be as worried about it with all of these other techniques as I would be about subliminal advertising. That's not to say that I think that there's anything that the law can or should do about it. So back in the 1970s, Steve Schifrin and Mark Yudof and Bob Kamenschein and a few others were making the arguments that government speech, in a different sense from current government speech doctrine, but that government speech ought to be subject to First Amendment constraints because of the uniquely persuasive power that government speech has. In our current, more libertarian age, not very many people would think that the fact that something comes from the government makes it necessarily more persuasive. But their concerns were, in a way, legitimate, not just that it comes from government, but that is, should we be worried about the persuasive power of particularly influential speakers, whether they are government or not? And I think the answer to that is yes. Should the First Amendment do anything about it? I think the answer to that is no. But the difficult cognitive scientific question is subliminal advertising different in kind, or is it just a somewhat more extreme version of what happens all the time, even if we don't want to admit it?
I guess I had a similar question about the nature of Asha's question is kind of going upstream of what Fred had described as upstream, right? It's like the inputs that go into the thoughts that then lead to potential action and whatnot. And one reason, especially in the libertarian area of First Amendment interpretation, one reason we might think that freedom of thought has to be protected is that even if others have that persuasive power, there's a kind of, it's hard to aggregate that power, whereas the government could act as some sort of majoritarian through some might wind up using whatever subliminal or other ways to affect thought in a manner that that suppresses dissent. Are there? But I guess that just leads me to wonder. Well, there are so many factors that are not purely communicative that still influence thought. Jordan, you mentioned this. You sort of described thinking still as the core or the root activity, and I guess I'm a little skeptical of that claim. That if you take the same person, at least, if you take genetic copies of the same person and put them in different environments, we know how different the person's identity, thoughts, and everything will be. And so I guess there are sort of two lines that wind up being rigid that might not be well defined. One is upstream of the thought, the things that lead you to think what you're thinking. And then the second one is the one that I think we were pushing you on before, downstream, when you, why thoughts are any different from getting tools before you commit a crime. Yeah, go ahead.
Yeah.
I guess
No,
that's a comment rather than a question.
Yeah, no, I mean, so this is, yeah, good. I mean, I guess what I would want to say in just response to the discussion so far is I would want to say that I'm not sure why it's, so I do think that there's different ways the government can operationalize infringing on freedom of thought. So I think, for example, restricting people's movements would infringe on freedom of thought, or for example, demolishing all the libraries near people, or creating substandard education. These are all things that would strike at freedom of thought. Not, for me, it wouldn't just be a matter of, couldn't the government switch people's thoughts using a light switch? That would be the most extreme version. I think, insofar as your thought is implanted, Fred, you talk in your article about implanting thoughts, in the same way that we can, put hats on people or something like that. That's an egregious form, but I think there's other forms of restricting it. And then I guess,
and would it matter whether the government whether the government made this, had this influence because it wanted to? Like, does the intent, I guess this is the Alana Kagan question. Should we be looking for whether the government means to be shifting thoughts, or whether it has a regulation that doesn't?
Yeah.
Regardless. Yeah, good.
Yeah, no, it's a great question. I mean, so I think intent matters a lot. An intent to distort someone's thought or to change it irrationally, I think is objectionable. I don't know if that means it's always illegal or if it infringes on rights or so forth, but yeah, I think the attempt to get someone to think something without trying to convince them of it, or engaging their rational processes broadly defined, is objectionable. But then I do think some things will infringe on freedom of thought just by the nature of what they are. So again, I'll just use freedom of movement because it's a kind of a orthogonal to the main categories we all accept as related to it, like speech and thought itself. But take freedom of movement, like I think if you said you can't leave your state or something like that, or you can't leave your city without a strong justification, of course there's reasons to restrict freedom of movement all over the place. But the question is, should it be subject to some sort of higher scrutiny? And I think, yes, your right to own a car is very different than your right to move around freely. I think those have distinct impacts on your differential impacts on your ability to think. And then in regard to some of the things about persuasion, like if I'm attractive or have a good speaking voice, those are things that may influence people, but those aren't things, that's where intention might matter. So I don't intend to bring those things to bear, although lots of things maybe in the background changes what's persuasive and what's not. And I also don't think it's a violation of freedom of thought to have expertise and authority that other people accept. That's how we divide cognitive labor. So someone says, take my word for it, and sometimes I do. And I don't think that's wrong. I think the boundary about what constitutes interference, for example, marketing was brought up. One of the things that makes marketing arguably permissive to some extent, though I don't mean to celebrate marketing, one of the things that makes it persuasive is you can go into your house and shut the door. We have privacy. Privacy helps modulate and regulate our exposure to other people's messages. And that line of privacy is partially, I think, justified precisely for that reason, because otherwise being inundated with a message can be violative of freedom of thought. I think that's quite plausible that can happen.
Fred, any follow-up thoughts?
I mean, that this is beginning to sound more and more like freedom full stop, more and more like autonomy. Autonomy is fine up to a point. Maybe I'm less of a celebrant of autonomy than others might be, but the more we expand the notion of freedom of thought, the more I begin to lose some sense of what is distinctive or what's important about it, or how we might attach a right with a capital R to it, as opposed to the way in which we somewhat less specifically, somewhat less operationally, might just celebrate it. Now, there's also the even bigger question that not very much about freedom of thought can address. How do we feel about people having the wrong thoughts? So it's, yeah, there are lots of people who have the thought that getting vaccinated is a bad idea. And I could take the next several weeks listing the bad thoughts that people have. So there is a question, which is not to answer it, that even if we assume for the sake of argument that other people's thoughts are manipulable, how do we think about all of the different methods and techniques that might manipulate people into having better thoughts than the thoughts that they now have? That's a dramatically anti-libertarian view, but maybe it exposes again just how much of this discussion is really about liberty as opposed to a particular kind of liberty or a particular kind of autonomy, or something of that sort. I mean, I might mention in the context of the existing literature. So when 50 years ago, Tim Scanlon wrote his still influential article in Philosophy and Public Affairs, he was particularly concerned with the way in which propositions uttered by other people might affect my decision about what to do and what not to do. Interestingly, and I believe correctly, in his more recent writing in this series of exchanges with Jim Weinstein and Shauna Schifrin, late Ed Baker, and a bunch of others, Scanlon seemed to be coming more to the view or more skeptical about the view that propositions uttered by other people have some particular pride of place in the inputs or the importance of the inputs in deciding what ultimately we are going to do. I think he's right about that, but I think it may undercut his view of, let's call it, listener autonomy as more central to freedom of speech than he thought 50 years ago, and may even think now.
I want to pose a question for Jordan that came in from the chat. So Benjamin, I'm going to murder this name and I'm so sorry, Akinmoyejehe asks, how do you decide which of my thoughts to select or punish when in a practical sense, I dwell on many thoughts and also I do not act on many of my thoughts? I think this can help you flesh out the probabilistic part, the difference between the pure versus probabilistic parts of your argument.
Yeah, great. So thanks, Benjamin. The thought crime doctrine, as it's currently enumerated, applies to all thoughts. So I would be in the paper I try to argue that categorical or blanket protection is justified. So I would think that some thoughts we dwell on for a long time, we keep them with us. They're kind of in the background, and we revive them from time to time. We revisit them. Revisitation is an interesting kind of connection to freedom of movement. But so I think it could be any of your thoughts. I think the ones you don't act on, I think it's particularly clear that those should be protected because their function for a thinker, when they're not the subject of action, their direct function is to come to grips with a view of the world, to come to grips with a picture of how things are, but not yet to take any action, but just to try to know the truth. And so I think that's true even of beliefs that are false. So even beliefs that are blatantly off base, their purpose is to represent the world correctly, though they don't in that case. That's what makes them critical to thinking. Now, you mentioned some maybe we do act on. And I think that's where that point returns us to what we were saying before. That's kind of a critical case, because when there's action involved, you can see that people will get worried that that is a place where we should step in. So if we could know someone's thoughts, we could just read them off of them in the park and they were dangerous, why not punish them? They're their thoughts. They're just as, it's debatable, but I think they're culpable. They're responsible for those thoughts. But yet I think they shouldn't be punished because they play this role in self-creation that we can't abridge, we can't get away from. It would be bad if we did.
But that comes back to the question of what is it special about punishment with a capital P? If we are accepting of, to say what you were talking about before, special surveillance based on the doodles that you write down during class, or suspension from school based on the doodles that you write down in class, or telling your mother, which to most 15-year-olds, maybe not this one from what I understand, is a punishment. What is it that's special about punishment as opposed to all of these other uncomfortable things that the authorities might do once they find out about your unacted upon thoughts?
Yeah, good. So the way I want to try to answer that is what I was trying to say in those cases, I think it matters a lot that the thoughts were obtained either innocently or justifiably. So the teacher is allowed to see what the students are working on during school, and so obtains the information rightfully. Or perhaps it's, in my example of the paper, I begin the paper with an accidental case. So someone accidentally reveals their diary, which has wrongful plans in it. And I think in those cases, the reason that you can act there is because you shouldn't have to ignore information that you find out about other people. And I think that's precisely the basis for privacy and for the protection of thoughts, which is that thoughts matter. Like, your thoughts will trigger other people to think their own thoughts, to take action, to get worried, to get scared. And yet it's important that we have that ability to think and kind of work out our ideas. So then I think that's what privacy is for. But if it's innocently breached and I find out that you're planning something, you might not do it. But if you are committed to that, so then we have to get into how much are you committed to it? If it seems from the writing that you're committed to a wrongful action, I think that we can put people in between you and your target. You know what I mean? We can surveil you. That becomes justified. But that's because the root action is not an attempt to access your thoughts. And so punishment becomes significant because punishment is an attempt to say that the thinking is the public's business, that this thinking is the public's business to regulate.
So let's say let me pose a hypothetical. Let's say we had a special machine that told us with 99% confidence that you're having X thought right now that will lead to Y illegal action. And it was accurate enough. Why would we not be able to use that machine to punish with a capital P, as Fred said, when we would be able to punish the guy who has an intent and has the break-in tools, but actually is only 80% likely to commit the actual crime?
Yeah. So, but punish that person for having the break-in tools.
Right. Yeah. Which is sort of a signal. It's meant, I think, to be a signal of probability, because otherwise having it is not that distinct from thinking it. I think, well, I don't know. So I guess that's trying to answer your question for you.
Yeah, no, I mean, good.
Can I add to that? Because I actually think Jane's hypothetical doesn't strike me as being hypothetical at all. I would bet that if not now, then very soon, we will be able to look at your Google searches and pretty easily predict, right, what information you're absorbing and predict the likelihood that you're going to act on it.
Mm-hmm.
But I don't think we'll get to 99% anytime soon.
No, but I still think it's 90%, right?
Yeah.
I mean, what's the difference between Google searches and burglary tools?
Yeah, so I think it's, so the paper, I haven't really thought through the deep justification that we could or could not give for burglary tools, for those rules. I was thinking that I was just trying to say in the paper, like, that those do seem justified. So why the difference with thoughts? That seeming might come apart if we don't think that burglary tools in the end, if my theory maybe causes us to rethink how we think about burglary tools. But what I would just say is, I would just say that the key is that what you're being punished for is for the burglary tools, for having the burglary tools. And I don't think your interest in having those is nearly the same, so that punishment can be justified. We said, don't own this thing. Now, you might not do anything with it, but we just make that general rule. And as a prophylactic, it's okay because it doesn't matter that much if people get to own their burglary tools. Is what I want to try to say. Yeah,
I'm
go
not
ahead.
sure if this is a question for you or for Fred.
Yeah.
But inputs into thinking are not just ideas. Right. Timothy Leary, going to the 70s, would have said LSD is an important input into thinking. So do we think that a ban on LSD poses freedom of thought issues, and therefore should receive First Amendment scrutiny?
So that's probably not for me, since I'm a skeptic not only about freedom of thought but about freedom of speech. But let me just add an example to this discussion, make it a little bit more concrete, actually, too. So if you read the literature on burglar tools, it turns out that most burglar tool prosecutions are based not on having one thing, but on having some combination of things, the combination of which is highly inconsistent with using them for innocent purposes. So if you have lock-picking tools and wrenches, and it turns out a broken spark plug, the likelihood that you are a burglar is very high. It turns out that the best way to break a window without making any noise is with a broken spark plug. Don't ask me why, but it turns out that it's true. Now, to bring this back to earth, if you talk to prosecutors who prosecute child pornography, most prosecutors who prosecute vigorously child pornography, even as they would say now, and even as they would have said 30 years ago, I don't care about adult obscenity, I don't care about sexual explicitness, child pornography is different. Most of them prosecute child pornography on their belief that it is either indicative, probabilistically indicative of current child molestation or worse, or that it is preparatory for child molestation or worse. And it may be, and interestingly, the traditional modern civil libertarian argument against child pornography prosecution looks very much like the discussion we're now having. The traditional civil libertarian argument is just because you like to look at pictures of underage people having sex doesn't mean that you will do it. It's all about your thoughts. So that you can decide what that means or doesn't mean, but it turns out that that may be the site in which this issue is most debated these days.
Well, we have reached the end of our hour. It's always, it's always a little disturbing when we end on a child pornography note, but that's how it worked out. I do want to let everyone know that we will have one last session in conversation with one of our Journal of Free Speech Law authors. We'll be talking with Nadine Strawson on next Monday. And we will use this very same Zoom link. So join us Monday at 12 noon Pacific time, and hope you're able to join us. In the meantime, I can't thank Jordan and Fred enough. This was so fascinating. And
Thank you.
Thank you for a great
thank you,
conversation.
Ash, too.
Thanks very much. Yeah, really
Thank
enjoyed
you,
it.
all of us. This was, I learned from this, so thank you.
Well, I learned enormously. Thanks, everyone.